Everybody. How are y'all?
It's fine. Thank you, Your Honor.
Mr. Cox, you're muted.
I'm good, Your Honor. Thank you.
I've read all this. First of all, there was a prior motion for summary judgment that I guess we never had to deal with because it became moot. Is that right?
Yes, Your Honor.
Yeah, and that kind of confused me a little bit because the way it said a hearing on the motion for summary judgment, and I wasn't sure which one at first. I'm pretty sure it's the one that alleges accord and satisfaction.
Yes, Your Honor.
That's what we're dealing with, right? And I've read it all. I'm just not sure what the purpose of the motion is. If it's granted, I think there's still going to be some issue of the medical records would come in subject to the amount that was reduced and paid. Is that?
I disagree, Your Honor. If it's granted, either way, the medical records for the hospital don't come into the bills because Mr. Pedroza has not paid those bills. He has not out that money. Those bills are paid on his behalf, not by insurance. It doesn't have to be repaid by him. But that's really a separate issue, I guess.
I think it is a separate issue that's really more for a pretrial than right now because it hasn't been briefed. But the issue right now is, and the reason that the summary judgment was filed was to narrow the issues, and so that accord and satisfaction isn't brought up at trial and a question isn't submitted to the jury. It's not a legitimate defense here.
Well, I think that if you got into accord and satisfaction, you have to get into insurance.
I agree, Your Honor.
Don't y'all agree with that?
Yeah, Your Honor. I think what we've got here is a case of the cart before the horse. I mean, this is an issue. This is all part of an issue that would be important in a pretrial discussion and limited discussions about what the jury hears and what the jury does not get to hear. And as to counsel's comment that it's not a legitimate affirmative defense, according to the restatement of torts, the Texas courts of appeals, it is very valid and it's very current. So, but I can argue that separately. But as to why we're having this discussion now, I think it's premature.
Okay. Well, the other issue, though, I think I don't think accord and satisfaction apply when it's not between the two parties.
Precisely, Your Honor.
According to the restatement of torts, the defendants can mitigate their damages, which is what this is, and we want to be sure that we are granted the credit for mitigating the damages, and that's the point of the accord and satisfaction.
I just don't think it's accord and satisfaction between the plaintiff and defendant. It might be accord and satisfaction between the defendant's insurance company and the medical providers. So, well,
respectfully, I disagree. I think the whole point of accord and satisfaction is to allow the defense that credit that they have satisfied that issue, and so that should not come up with the plaintiff at all. It becomes a non-issue.
Okay. Well, but I think that we'll deal with that as the trial happens. And we used to deal with this, the paid incurred stuff after trial, where the defendant's entitled to a bunch of credits for reduced medical bills and those types of things, just to avoid getting into insurance. And so I'm just not sure how it all applies. I don't think it's a court and satisfaction though. So I'm probably going to grant the motion for summary judgment.
Well, Your Honor, the rules apply. Say, I think it's 95. I can't remember exactly which one off the top of my head, but we have to plead all of the possible affirmative defenses, and that's what we wanted to do here, was to make sure that we're following the rules. We can't argue it if we haven't pled it. And so I think to not have that available, we have to plead it according to the rules.
Well, I think what will happen is I'll probably grant the motion for summary judgment, but you're going to be entitled to a post-trial credit for any money that's already been paid against any medical expenses.
Well, and we're going to have an issue with that, Your Honor, because those medical expenses should not be presented to the jury, because under Escobedo, they are not paid or incurred by him. They are now, it's gone. So whether it's a plaintiff's verdict and they get an award of money, well, the one person here who benefits is Mr. Pedroza, because he doesn't have to pay that back. In the event of a defense verdict, the one person who benefits here is Mr. Pedroza, because it's paid. So to put that $12,000 before the jury as an expense, the jury, that's misleading the jury as to what the expenses are.
Y'all, you disagree with all that?
Your Honor, yes, I mean, again, I think this is an argument for another day. I think that right now there's obviously no evidence supporting submission or an affirmative defense of a court and satisfaction, and the summary judgment should be granted. Regarding what evidence comes in at trial regarding medical bills or anything of that nature, that's something that can be addressed addressed in pre-trial, or as Your Honor suggested, as post-trial. But regardless, the court and satisfaction does not belong in this case. It's just simply, it's not applicable under these circumstances.
Okay. Well, what I'm going to grant the summary judgment motion, but understand they're going to get credit for what's been paid if the time comes for that. So if they've paid money, they're entitled to a credit for that money that's been paid. So we'll deal with that down the road, I guess. So, okay.
Your Honor, can we maybe submit an order?
If you would, yeah.
Just granted. Thank you. We can do that today.
All right. Thank you all.
Thank you, Your Honor.
Thank you.